loan mean or the successor in title, because we don't have a mandate insofar as those issues are concerned. We are here to account for taxpayers' money that has been used in order to meet the claims that have been lodged against organs of state and state departments. And admittedly, as it was when we first reported on these issues, these are emotive issues. There are quite a number of other demands that are required from government. We don't have the mandate to talk to any other aspect beyond the damages claims that have been lodged with us. We accept that attorneys, as it is with the Office of the Solicitor General, are creatures of instructions, and we can only do so much that we are instructed and within the ambit of the instructions that have been entrusted on the Office of State Attorney. And for that purpose, I need now to revisit the previous reports that we have made, update them up to today, being the 17th of August, and if and in the event that there are questions, my two colleagues that are with me will be able to deal with some of these questions. And at the outset, let me try to indicate that the Marikana incident of August 16, 2012 actually is a painful and remains a significant and solemn chapter in our nation's history. And it is something that we cannot actually downplay because people are still impacted emotionally. And it casts a somber shadow over the tragic clash between striking miners and law enforcement, resulting in multiple fatalities. As a result of which we, as government lawyers, are now seized with having to meet the demands that have been lodged with us, lawful demands that have been lodged with us. And so there is always a narrative of actually confining the fatalities to only 34 individuals. In our book, it's actually 34 plus another 10 that is never accounted for. We also, in fact, need to take that into account. However, in relation to the 10 miners that died before the actual miners, we've got no claim whatsoever that has been lodged against government. And I know that last year there were questions of saying, talk about the other 10. The other 10 that died, there was no causation on the death itself that was attributable to government or the state. And their settlements might have been settled by other individuals. The claims that have been lodged, as we have already indicated, the legal representations, and we repeat. And I think it is more important to repeat the facts so that they are properly recorded. We have actually indicated before that we had the Vets Law Clinic, we had SIRI, the Socio-Economic Rights Institute of South Africa, we had Maluleke Msimang and Associates, we had Tata Attorneys, we also had Nkome Attorneys. And any other claim that might have been lodged with us, or any other person that in fact attributes a claim that has been lodged with government outside of this, might have to check the facts, because these are the matters, or these are the entities that had lodged claims against government. I will go now and, in fact, attribute the number of, or total of claims that have been lodged by each of the entities that I've listed, 6 in number. I must actually just correct, I think 5 in number. The status of the claim, or the claims as lodged, in relation to the Marikana landscape are as follows. The Vets Law Clinic only lodged one claim. And that claim, as we speak right now, had been finalized. And this has been our stance since 2021 that we paid 3,995,121 plus costs in relation to that matter. And then SIRI has taken up the cost of families associated with 36 deceased minors, with 34 families securing settlement for loss of support amounting to 71,230,491 rand. Notably, SIRI has introduced the novel concept of constitutional damages, which is a new head of damages. And I think this is what we are going to be seized with, because the residual issues that are actually being dealt with on behalf of SIRI relate to this novel issue of that is called constitutional damages. It's new. It raises a number of issues. It raises emotional damages and a whole lot of other aspects. But for the record, we have paid via SIRI or under the auspices of SIRI 71,230,491, and I need that to go on record because that's what we paid for. And then we have paid through Maluleke Msimang attorneys, and they've actually been able to secure settlements for 15 of the claimants. And the total amount that has been paid to Maluleke Msimang via their trust account is 77,034,643.70 for the record, representing the 15 claimants. There is no straight quantification, a straight line quantification of those amounts. The amount might be varying on the 15 claimants. However, the quantum that we've paid to that law firm in relation to these claims is as I've already outlined. And so I think outside of those 15, I have not been given any other additional individuals that were represented by Maluleke Msimang beyond the quantum that we paid or committed from the state, which is taxpayers' money, in the sum of 77,034,643.70. Tlatla attorneys dealt with or handled matters relating to assault and gunshot. Progress is underway with certain claims still undergoing verification. But those claims, I think Mr. Chowe can speak to, because those are residual issues that needed to be dealt with. In relation to that law firm, we have paid through its trust account 51,803,863 rands and 66 cents. The last law firm that in fact was representing claims and have managed the interests of two distinct categories of plaintiffs, those that were arrested and those that were detained. We have in fact, as the state, utilized taxpayers' money in the sum of 102,305,000. It's a straight line. 102,305,000. And that, in fact, is in settlement of 10 of the 12 matters that they've lodged with us. Now, where are we? The total amount that we as the state have committed, the aggregate total amount is 330,445,630 rands and 37 cents. And this has been disbursed to the legal representative mentioned above. That's the figure that in fact appears on record. That's the figure that has been audited, and that's the figure that we stand with or about as we speak right now. And these funds have served to address a spectrum of claims that related to legal consideration stemming from the Marikana incident. I repeat the amount. The total quantum that the state has paid thus far is 330,445,630 rands and 37 cents. I now deal with the issue of the because it's reported widely. I think I also saw a report yesterday that the state is vacillating, dilly-dallying, and not actually dealing with the rights of the claimants meaningfully. I must actually indicate that from where I sit, except for one or two matters where quantification still needs to be worked out, which in fact will add on to the globular figure. We, as I've already indicated, are creatures of instructions. Where a new concept as the matters stand now is introduced, such as constitutional litigation, which was not existing as at the time when the incident happened. You are finding a situation where you are applying the law retrospectively, and we need to get instructions from the South African Police Service and everybody else. And we are actually having to deal with the issue of what is this concept of constitutional litigation? Why was it not pleaded as and when the matter started? And as creatures of instruction, where do you then derive the powers to settle on an aspect using taxpayers' money which has not been ventilated in court? And for all intents and purposes, until and unless there are new developments and there is cogent argument that is presented before any court of law about any novel or a new issue that arises out of the Marikana litigation, I think we have done enough. And the question that needs to be asked is, how long is a piece of string from where we are? And I've already, in fact, indicated that our mandate is only to deal with management and coordination of a litigation relating to the Marikana incident. I don't have any further mandates as matters stand, and should the court decide that the issue of constitutional damages, which in fact is being preferred by Siri, and I've actually sat with them, and this is an issue that arises from the life Esidimeni issue, when former Deputy Chief Justice Museneke actually lifted that issue. It was not there as and when the Marikana incident happened. So we need some intervention insofar as that issue is concerned. But that intervention is above our pay grade, and we are not going to invent a new issue and hope that we'll get money to pay in respect of that particular issue. And that is where we are as at the moment. In culmination, remarkable strides have been realized in the strategic orchestration and harmonization of the Marikana litigation. This is our statement as we speak right now. The resolution of numerous claims stands as a testament to our unwavering commitment to justice and due process. However, the introduction of the constitutional damages concept, as I've already alluded, is something that we do not actually have instructions for. The papers have not been amended such that we can actually go to our principals and say, here is a new novel issue that you need to budget for, and therefore it is actually above our hands. It is a concept that is introduced and deals with residual considerations, inviting contemplation of the crossroads of the law and ethics. And to the extent that it in fact elucidates the crossroads of law and ethics, we don't have instructions in relation thereto. But it is an issue that we are prepared, upon instruction, to explore. And ladies and gentlemen, these are intractable landscapes that we are dealing with. I've already indicated how much we have committed from the state. And I will, DG, leave it at that, on that note. Thank you very much.
Thank you very much, Solicitor General Pedisani and Delani. Colleagues, let me first introduce the colleagues who are going to be assisting us with the questions. Next to the Solicitor General, we have Mr. Isaac Chowe, who's the Deputy State Attorney from the Office of the State Attorney in Pretoria. And next to him, we have Ms. Mohube Pahlane, who's the Deputy State Attorney from the Office of the Solicitor General. Then we will first take the questions from the room. You introduce yourself and the media house that you represent. And then we move to the online questions. Yes, Aviwe.
Thank you, Aviwe Mtila. Solicitor General, maybe can we get an understanding of how many more claims are outstanding, the number that you haven't settled? Because, for example, you mentioned Siri, and Siri suggests that it's only one heads of damage that's been settled out of the 5. There's still 4 outstanding, and the state is basically running around refusing to sit on the round table with them to discuss a way forward around these 4 heads of state. So the money that you've been mentioned is only just one of the 5 heads of state. And I understand these are civil matters, and you mentioned that you'll shy away from dealing with the criminal matters, but I think it's important to find out why the criminal prosecutions, especially around the 34 mine workers on the 16th of August, haven't been dealt with. Why is the state even running away from actually dealing with those? And for example, we've spoken to even Nkome attorneys that you mentioned there, which suggests that for their legal their people, what they want is a mere apology from President Cyril Ramaphosa just on the characterization of the labor dispute into a criminal act rather than the labor dispute that it was. They want an apology basically from the president. Will that be forthcoming?
Okay, thank you, Aviwe. Do you have any other questions in the room? Okay, Takalani, can you help us with the online questions?
Thank you. Very good, DG. So far, we only have one question from Angelo Coppola from China Global Television. And the question is, does the state now consider its duties fulfilled in terms of the 34 miners? Thanks.
All right, thank you so much. Solicitor General will allow you to come in with the responses. Thank you.
Thank you very much. Let me start with Aviwe. Aviwe, issues relating to Marikana are multifaceted. I think you will be the first person to agree. As you see me standing here, I'm not the spokesperson for the NDPP. My mandate is completely different. So to want me to venture to deal with criminal prosecutions, I think is exacting, to say the least. I deal with, and my mandate deals with, management and coordination of state litigation from a civil law perspective. There was a report that was issued yesterday by the NPA. And for me to punch above my weight and start arrogating to myself the right to speak to something that belongs to another branch, I think will be unfair. I think you admit to that. So please don't get me to venture into areas which do not fall within the realm of what my mandate is. Mine is a singular line that I'm dealing with, and that is why I'm saying issues relating to Marikana are multifaceted. I will deal with that which in fact fall within my competence, and I've actually done exactly that for the past 3 years until now. Now, the issue of an apology, the question is, would you then say it is an apology that must be issued by government under the auspices of the Office of the Solicitor General, or is it something that it also resides elsewhere? I think you'll be the first person to admit that it does not reside within the piece or prescripts that in fact fall under me. So this is not like an organized government press statement where you've got NPA and everybody else in there. This is just one singular window to enable you to see the inside of what we are doing from our corner. But we do not have delegated powers to be speaking to all the other people. And I know the interest that you have probably would be from this same sitting, let's get a globular view of what it is that is being done. And I think you'll understand that ours is limited. State attorney, creatures of instructions, Solicitor General, creatures of an Act of Parliament and instructions. So we can only talk about that which falls within our space. And that is where we are. I will then actually leave the issue of whether we believe we have holistically exhausted all the claims as we speak right now for my colleague, Mr. Chowe, to come and actually talk about that issue, because operationally, he is the one that sees the day-to-day running of those matters, and he is the one that understands the difficulties that are there at the coalface. And if we say we have actually exhausted the claims, that is what we mean. I've actually also said, how long is a piece of string? So you can get today money today and wake up tomorrow and say, oh, by the way, we are settling this thing in piecemeal. There is nothing like that in law. There is something that is called the once and for all principle. You don't settle matters piecemeal. It's without prejudice, but in settlement of all the issues by and between the parties. Now, what we are seeing is a novation of something, the claims. Oh, okay, there's another aspect that we ought to have actually been included in what you paid us. Now, do I pay you 77 million rand, Aviwe, today? And 2 years down the line, you come back and say, oh, by the way, that 77 million rand that you paid me, and I'm not making light of this very serious issue. I'm talking about legal principles. Is it acceptable that the state can commit 77 million rand now without an understanding that, this is like a payment in tranches? When you pay in full and final settlement. Now, you're hearing reports saying there are 4 heads of argument. By the way, you said 4 heads of state. I'm just correcting for damage. No, I agree. It's just in a light-hearted moment. Why do you accept settlements in piecemeal? So let's also zoom into this space of constitutional damages. Where do you see constitutional damages in the papers as pleaded? And I don't want to introduce a situation where we now start litigating through, press briefings. I'm actually talking about real issues, because these matters have been with us, for 11 years. And at some point in time, we really, really need closure to these matters. We're dealing with active matters now, 386,000. Now, just imagine if we were to wake up every day and have a press briefing in relation to all of those matters. Then government can never function. Just imagine government from taxpayers' money, something that is audited, paying 331 million rand. 11 years down the line, people still flock back, the same claimant saying, no, by the way, it's not enough. It's not legally permissible. If you're talking political intervention, that's something, it's also outside of the scope of what I'm talking about. Now, I will leave the rest in relation to Gome to my colleague, because that's the most difficult question. I will talk about questions that are not difficult. I will delegate the difficult ones. The issue of the apology I've already indicated to say, look, it probably resides somewhere, not with state attorneys. Honestly speaking, I can stand here and say, I'm sorry. You are going to write very negative statements about that. To say the Solicitor General was clowning about, standing before a mic and saying sorry on behalf of government. You are not going to accept it yourself. Where do you want that apology to come from? GCIS, presidency, cabinet. So I don't want to venture into all of those things, because I don't have a mandate as I'm standing here in front of you as the Solicitor General. My mandate is management and coordination of state litigation, including the Marikana litigation, which admittedly you will be the first one to say we have never actually publicly stated these things. Government has been lambasted for 11 years. It was only in 2011, after my appointment, that we started, in fact, revealing some of the statistics. In fact, there was this false narrative that government has not paid a cent for the longest of time. And we are saying, yeah, there are figures that we are in fact talking about, figures that have been audited. On that score, DG, let me allow Mr. Chowe to talk to the other issue of the 34, whether he believes the 34 minus is, covers everybody. Thank you.
Thank you, DDG, SG, and friend Aviwe. As the SG says, we are more, as the state attorney, as a deputy state attorney, more on the operational side of issues. So I do have figures which were provided to me by an attorney who reports in these matters, who is on a daily basis making sure that these matters appear before court and so on. So maybe I can start with Seri Aviwe. On the Seri matters, you'll find that they were representing around 36 deceased minors. And out of this 36, we have, as the SG has explained, that there are also additional heads of constitutional damages as they've been brought. The report which I have and which I can give is that out of this 36 families, there is also an additional number of around 320 family members who are saying, but we need to also get kind of claim. So these are being dealt with, as the Solicitor General have said. They are still in the courts, and we are able to say yay or nay will be able to deal with these issues. So out of this 36 from Seri, the figures which were given by the Solicitor General, we have paid 34 families. And the other 2 remaining families, there is a possibility that the 2 other claims will be capable of settlement. So the attorney in this matter, including me as a supervisor, are working to make sure that these issues are dealt with, and the 2 claims from Siri should be dealt with. The other 300 or so, it's another issue which the SG has explained in full, that the heads of damages, it's a very new thing which we still have to ventilate in court. So that issue, as the SG has already explained, the Deputy Judge President is actually case managing that side of the issue. And I think, as you know, there's this principle that we shouldn't meddle into the affairs of the court, and I wouldn't want to go that far. And then on the issue of the Maluleka Msimang attorneys, we believe that all those 15 claims have been paid in full. And then we go to Hlahla attorneys, who represented 27 plaintiffs. And out of this 27, there is 2 claims who appear to be untraced. Even the attorneys, they cannot trace these 2 claimants. But we have paid 17 claims out of that 27. And having said that, the other 7 plaintiffs, they were referred for medical legal examination, so that we will be able to quantify the claims for this 7. And the parties, or should I say the attorneys, are busy discussing how do they approach the reports from the medical legal experts, so that we will be able to quantify the claims. And out of this, I have reported that 1 plaintiff has died before the close of pleadings, and there's no further litigation in this matter, and we have closed it. So for your information, viewer, what usually happens in litigation is that we say close of pleadings, meaning that the matter before court have finalized. You have put in your claim, I've pleaded that I accept or I do not accept. So this particular individual referred to, a singular one, was that unfortunately passed on even before the pleadings were closed. We have not pleaded, so that matter, one way or another, it's not proceeding. Then we have Nkome attorneys to 275 plaintiffs. And we have settled around 264, if my notes are right. And out of this, we are proceeding with 10 of them. And the 8 have been settled. We have settled the 8 claims which were done. And 1 claim, an offer was made to the attorneys for them to accept it. 1 claim, the attorney has recently provided supporting documents for the amount. So it's more or less the same as referring a person to a medical expert to say whether this person, what kind of assistance will he need or will she need in the future, and what might be the cost of whatever damages which the person needs. So this is also being discussed between the attorneys. So these are the figures which I can give you, but the total amount paid is as stipulated by the SG. SG, I hope I have answered adequately. Thank you.
All right. Thank you so much, Mr. Chowe. Colleagues, we're coming to the final round of questions. We will start in the room, as always, and then we will move to the online questions. Aviu, I can see you want to say something.
Just a clarification from the Solicitor General. On the Seri matter, you seem to suggest that you as a state have done enough. I just want to understand, because they're saying that there are 4 heads of damages that are still outstanding. You as a state are saying that you've paid your 77 million, that's it, or what's the way forward with that?
Okay. Thank you, Aviu. Takalani?
Thank you, DG. There's a question from Eyewitness News, and the question is if the SG can clarify the exact number of claimants that have received a portion of the 330 million rand. And Christian Duplessis from NetBar 24, how much more claims have not been finalized, and how much more money could be paid out to claimants? Thank you.
Okay. Thank you, Takalani, very much. SG, we will then take you. I think this is the last round of questions, so you can also conclude.
Okay, thank you. All right, let me deal with the issue. Takalani, where was the other question coming from? The one for the exact number. Is it newsroom or is it News 24? Oh, I see. Okay. No, that's fine. Mr. Mtil, there are 2 concepts that are involved. There is what we call common law damages. It's traditional delict issues. You know, either you claim for your own personal injury if you're still alive, right? And the sequelae. Special damages. There will be past medical expenses if you've been hospitalized, for example. There will be future medical expenses, which is an exposition of what it could be or what it will take to restore yourself to the position that you were before the incident. There is what we call, pain and suffering. And that pain and suffering would relate to you in person. No one can actually have a claim for pain and suffering on behalf of a third party. But if that human being is no longer alive, unfortunately, what we then have is loss of support, right, by those that are surviving, because when you die with your injuries. Right? We cannot treat those things. But I just wanted to make that clear. Those are traditionally what we understand delictually to be aspects that are claimable in our law. Now, I don't know how much you remember of the Wimbledon tragedy, similar to the Ellis Park tragedy. You probably will know the Ellis Park tragedy. Now, what we are getting is the expansion of areas under which a lawsuit can be lodged. So you are saying Siri is alleging that we only dealt with one leg of the damages. Yes, we dealt with what is commonly understood to be forming part of what we call common law damages. The other aspects fall within the realm of constitutional law damages. If you take, for example, the Ellis Park tragedy, what in fact it takes is, if I'm an uncle to 20 kids in a village and they see me involved or being at the center of a turmoil or a tragedy, watching me on TV, the extension is they too for emotional damage and harm can claim. Do you understand the difference? So that's the difference, and I don't want us to, in fact, have a debate as if it's in a classroom setup, but I'm trying to minimize so that even people that are watching this understand what we are talking about. So constitutional law damages, it's a novel thing. If you hear Mr. Chowe saying, we settled with everybody else within this number of people, say 34 or 36, but there are now extended cousins, uncles, aunts, and everybody else who are saying there was a nexus between us and the person that was injured at Marikana. And for that reason, we also suffered some pain. I don't know whether you understand what I'm saying. Now, it will be absurd of me to sit here and say the whole village from where I come from at Amasia is entitled to now lodge a claim on the basis of me being involved on something else. It's absurd. It's unprecedented. Those heads of damages that you are talking about fall within that realm. And indeed, they could be 20, they could be 100. But traditionally, that is not what, in fact, we are known to actually cover, at least as at the time of the incident. But what compounds the issue is there is no cogency in the pleadings that have been made in relation to some of these other people. And even the relationship, the nexus, still has to be proven. The absurdity of it all is you can actually go and understand me. I'm actually so passionate about having to deal with these matters. I don't want to make light of it, but also we should not politicize a very simple delictual issue and expand it beyond what it is intended to mean. Now, if you are going to bring me a busload of people and say they were related to this person, what is required of you to prove? Those are issues that we are dealing with now, because there is honestly no slush fund, Mr. Mtila, that is awaiting to settle claims that traditionally we don't actually recognize them in our law, irrespective of the number of damages. But I'm also going back to the issue. The once and for all principle says, if you are pleading in the same papers that I owe you 100 rand, and I don't compromise any cent of the 100 rand, and I pay you 20 rand, you honestly cannot come back 5 years down the line and say, hey, my brother, remember there is another 80 rand that we need to interrogate. That's not how the law works. And I think I've over-explained that issue, and I do not want to over-explain it to an extent where within the category of people that in fact might be entitled to constitutional law damages, I do not want to appear to be watering down their claims. We still are saying, notwithstanding the fact that this is a novel area, this is not private to private, this is government to the citizen. We are prepared to sit down, but at least give us something that indicates that there's a nexus for us to use taxpayers' money to meet your demand. Because the day when you are going to bring me a minibus of people and it is discovered that they were not even related to the deceased, then you will be the first person to say, I've abused taxpayers' money. So let's avoid that. Let's have a common understanding. And in fact, what is beautiful is, outside of all of us talking about these tragic issues and settlement and things, these people are represented by lawyers, right, who have been to law school, that should know much better than any debate that we can have here. Let them bring the arguments. There is a deputy judge president that has been case managing this issue from the last time that we were in this room. On the 15th of August, 2021, there was a case managing this issue, asking the same questions to say, outline the heads of damages that you are saying are beyond the common law right damages, pertinent to delict. I think we together there. I don't know, I think the next question that Takalani actually had to deal with was the total number that is attributable on the 330 million rand. Have I captured it correctly? All right. No, thank you very much. Let me break it down as follows. There could be one or two other people that, in fact, might not make the number to be exact because litigation, especially for personal injury, is related to the person. And at times when we say we want to settle your claim and we require the person to come for medical legal examination, and that person is not there, questions must be raised. If I don't know that you exist and we are saying come for medical legal examination because you are claiming so much under these heads of argument and you are not there, then it means we might not be able to entertain or finalize that claim. And so, as Mr. Chow has already indicated, there is a case where one or two people cannot be located. The question is, if we're to pay money on behalf of those individuals, and it so happens that they were never born to start with, on whose behalf are we disbursing taxpayers' money? Those are questions that we need to interrogate. We can only pay for a claim that has been validated, where the medical records can be related to a person, and we can only pay for loss of support by people that had, in terms of common law, the principles of dependency on that particular individual that has died, but also, conversely, the need to be supported. Now, old as I am, and I've got a kid who is 49, married somewhere. Opportunistically, when I die, they come back and say, no, we want to claim because our dad, in fact, died. That's not the test. The test should be where they depended on me to start with, as at the time when I died. So, just to deal with the issues and the numbers of matters that we settled, might have to enlarge my glasses. This man's phone is not actually going to be very helpful. The claims for loss and support for the 34 families have been settled as follows. The 71,230,000 that I alluded to. Mr. Cho, you might have to give me my own device. Yours is very dicey. It's more sophisticated. I was born before technology. No, the phone. You'll have to bear with me because that's your phone. I don't even understand your notes. I will take just 2 seconds to answer to the question that has been raised in relation to the figures. I don't actually have them at the top of my head, and neither can I be able to give false statistics about individuals because these are aspects that have been audited, as I've already indicated. And my just by way of repeating, we have paid to Vets Law Clinic 3,995,121 rand plus costs. That's one of the matters that have been settled very early on. So that's one. And that is for loss of support. So it could have been for somebody that was a breadwinner who died and supporting so many kids. And then that money, actuarially calculated, was sufficient to support that family based on the status of the person that has died. We have actually indicated that Siri, and Mr. Mtila, this is where we go back to it now. Except for those that cannot be traced, we have settled with Siri for 34 families. They've lodged claims for 36. I might not be able to deal with why they know why we are not settling the two. And that's not the issue now. The issue is, as you will see, we have paid them. And I know that this is perhaps going back because this is the same question that they are asking. So it's 34 families. Whether you divide that money on a straight line or otherwise, it doesn't really matter. At the end of the day, the money that we in fact requested Treasury to make available to settle those claims was 71,230,491. for the 34 families. Now, that money is gone. It's gone from Treasury, right? Now, the same grouping says we've got relatives. We want to claim for constitutional damages. You understand where we are going. So each and some of the families, and I'm not making any light of these issues. These are grave issues that we need to, in fact, deal with, feel the pain, commemorate as we go on, but we need to bring these matters to finality. And so, as we stand right now, from the 34 families, we have actually paid for loss of support, right? 71,230,491. Then, let's interrogate, and I'm answering that question, Takalan, but I need to finalize this thing in 1 minute, DG. Having settled 71 million and those cents, and this is what SAB says is the second bite on the cherry, right? This is what we are told. So what are you doing? You hoodwink us to pay 71 million rand, and after we've paid 71 million rand, you come back and say the 34 families are saying we must pay more. This is a very serious issue. And we've got a client. The client says, explain to us what it means. From the baseline budget, we need to now go back to Treasury and request additional money to pay this layer of other individuals. And of course, I could be taken to task, but I'm representing government as I stand here, Mr. Steele. And I need to speak truth so that we in fact record these things once and for all. So the associates, relative, and everybody else of the 34 deceased are saying, why did you leave us behind? We want in. This is the second layer of quantification now. And then we say, okay, fine, let's talk. And we realize that it doesn't fall within the traditionally understood concept of delict. It transcends, it deals with something else. I was related to him, therefore I'm entitled to 5 million rand and so on and so forth. That's the argument, by the way. You won't prove that in court. We can actually be talking here for another 11 years, Mr. Mtila. We are not going to agree. But fundamentally, even if I was to be so empathetic to an extent where I say, you know what, please, and the legal team tried, by the way. They tried, they wrote a memorandum, and the client said, no, go find the money. I'm sitting here, it could be career limiting for me to, in fact, say to you now, standing here, we will find money to settle those things. It's above my pay grade, and I'm not going to commit. So to answer that question is 34 families. Then that in fact might actually cater for everybody else that perished in that unfortunate date on that day, excluding the 10 that had perished before. I think if we've got a common understanding, then we'll understand what we are in fact getting at. It's commonly reported, I think the numbers will vary as to how many people perished. And if you paid for 34, your guess is as good as mine why the other two might in fact be excluded. And then just perhaps to finalize this issue, DG, there were additional plaintiffs that claimed, and I've indicated that Maluleke Msimang has actually dealt with those that claimed for injuries, arrests, and detention. And there were 15 from that law firm. We paid in relation to the to that group. We paid, the records that I have is we paid that law firm 77,034,643.70. Arrest, detention, and injuries. Not people that died. These are people that are alive. The next category would be plaintiffs that were subjected to assault and gunshot wounds. There could be one or two where perhaps they are now still quantifying the issues of future medicals. But in relation to those, we've paid for 17 claims under the auspices of Tata attorneys. We paid them 51,803,000 just globally. And then we paid under the auspices of Nkome attorneys. And under two heads of damages, arrest and detention and injuries. Now, in relation to arrest and detention, and for the purposes of the question that came through, we had 264 claims. In relation to injuries. And for those, the state paid 102,305,000 rand. And then there were 12 matters which were presented to the state on assault and detention. And that, in fact, that figure might falls within that quantum that I've indicated. The total amount paid, 330,445,630 rand and 37 cents. DG, I think I've done enough to try and elucidate the issues and answer to all the questions. Thank you very much.
Thank you so much. And from the social media, we have also have a question posed to us to say, in 2021, you told us you were not able to settle for the two families. That is the ones from Seri. What were the reasons for what were the reasons for settling? Maybe the question should be, what were the reasons for not settling? I would suggest that as the SG has elaborated on this issue, most claims of this kind, one needs to quantify all the claims. It may be that at the time when the matters were brought before the state attorney representing the state departments, that there was not enough grounds for us to try to talk about the settlement of the matter. And my answer to the two families or the two claimants was that the claims are capable of settlement. So they have not been settled as yet. And I will suggest that the reasons for non-settlement for these claims, it might be that the quantum itself has not been determined. And as soon as the quantum has been determined, there should be a possibility of settlement of these matters. Thank you.
We've now come to an end. We just want to thank the Solicitor General and Datefe Disani Vandelani for the report that he has tabled before us. It was a report on the status on the management and coordination of the Marikana related litigation. Thank you so much, and from the colleagues from the Office of the State Attorney in Pretoria, to all the media houses that have managed to come and the ones that are streaming live, ensuring that the citizens are informed. We really appreciate that. We have come to the end of the session. Thank you.